Now, please allow me to introduce your speakers for today. Monty McIntyre is a mediator, arbitrator, and referee with ADR Services, Inc., who helps settle cases as a mediator and conducts focused hearings and issues fair and impartial decisions as an arbitrator or a referee. Monty handles cases in the areas of business, commercial, employment, insurance, bad faith and coverage, real property, and torts, including elder abuse, medical malpractice, personal injury, and wrongful death. Monty brings extensive civil trial experience to his work as a neutral, having represented both plaintiffs and defendants in a wide variety of civil cases in the areas listed. Monty has been a member of the American Board of Trial Advocates since 1995, is a past president of the San Diego County Bar Association, and is also a past president of the San Diego chapter of ABOTA. Finally, Monty is a publisher of California Case Summaries, which provides annual practice area, quarterly, and monthly civil case summaries of every new civil case published each year by California courts that can be read in minutes, organized by legal topic with the official case citations. Next, Mike Roberts has been a full-time neutral for the past 30 years. He has served as a mediator and a special master in over 4,000 cases with aggregate settlements in excess of $800 million. His mediation practice consists primarily of major financial controversies and complex multi-party matters in the areas of employment, construction, business, real estate, and insurance. He has been named as one of California's top 50 neutrals and is a frequent author and speaker on various topics related to mediation, negotiation, and other forms of dispute resolution. So Monty and Mike, passing it to you.
Thank you, Hayward, and thank you to ADR Services for letting us make this presentation to you today. And Mike, thanks for helping me with this presentation today. So Hayward, if you can go to the next slide. The California courts issue hundreds of new civil cases every year. And last year in 2024, there were 348 new civil cases published by the Supreme Court and the Courts of Appeal. Actually, last year, they worked a little less hard than they did the year before, because in 2023, they were in the 400s. And actually, in earlier years beyond that, sometimes it was over 500 cases. Last year, the California Supreme Court worked a little harder than the year before. They published about 31 cases last year, and the year before, they only published 20 cases. So before we get to the cases, I do provide these case summaries, one-paragraph summaries with California case summaries. And one of the things I'm doing with people who mediate with me this year for a half-day or full-day session is I have a monthly issue, and it normally costs $150 a month. And if somebody mediates with me, they can get 3 free months of that subscription. So it's a $450 value. So you get to see what they look like as we go through these cases today. And there's also a link, if you get the written materials, to get free the summaries of all the Supreme Court cases from 2024, and you can click on that link. So Hayward, let's go to the next slide, please. One of the very most common things, or a very common thing that we see in the cases throughout the year, are arbitration cases. Now, these cases come up in a lot of different contexts. One of the common contexts can be, what if you have somebody who goes as an elder person and they're admitted to a nursing facility, and commonly those facilities will have some kind of an admission form, and it may include an arbitration clause in it, or it may have a separate agreement where somebody is asked to sign an arbitration clause. And of course, if a dispute arises and the nursing facility gets sued, they're going to request arbitration, and the plaintiffs will often oppose that. That's what happened in this case. And in this case of Herod versus County Oaks Partners, the plaintiff filed a lawsuit for problems that happened, alleged negligence and elder abuse, when the plaintiff was in this nursing care facility. Now, he had fallen, broken a femur, became unable to walk, and was admitted to this facility to get living assistance and rehabilitation. And he was in there for a month or so, and he had, before this happened, signed a power of attorney for health care, empowering his nephew to be his healthcare agent. Now, the power of attorney was not a statutory form in California. It was, in fact, more of a California Medical Association form. And so the nursing facility had a state mandated admission form, and that was unalterable. And the nephew signed that, and they also had a separate arbitration agreement, which the nephew signed. So in this case, the Supreme Court affirmed the Court of Appeal, which had also affirmed the trial court order denying a motion to compel arbitration. So what happened was that the Supreme Court concluded the execution by the nephew as the agent of the optional contract for arbitration. It was not a healthcare decision when the healthcare agents within his authority as a healthcare agent, and therefore the trial court properly denied that motion. So let's go to the next slide, and Mike will discuss that.
Thank you, Monty. The headline for this case, Quach versus Cal Commerce Club, is the California Supreme Court eliminates prejudice requirement for waivers of right to arbitrate. This is a case that rose out of an employment situation where the plaintiff sued his former employer after he was fired. In the answer, the defendant asserted that the plaintiff had agreed to arbitrate disputes. The defendant also initially demanded a jury trial and over the next year engaged in significant discovery. Over a year later, after the complaint was filed, the defendant first moved to compel arbitration. The trial court denied the defendant's motion, ruling that it had waived its arbitration right. The Court of Appeal reversed the trial court using a test set forth in a case called St. Agnes Medical versus Pacific Care, saying that the most critical factor in determining waiver is whether the party resisting the motion to compel had suffered prejudice, and in this case, they found that there was no prejudice shown. 2 weeks after the appellate court ruled, the United States Supreme Court rejected a similar rule under the Federal Arbitration Act, basically saying no prejudice need be shown. You look solely at the actions of the party seeking to compel arbitration to determine whether there's been a waiver and whether the opposing party, the party that's resisting arbitration, is prejudiced or not. That's not a factor to be considered. And so the Supreme Court in California adopted the U.S. Supreme Court's rule, and you do not in any fashion need to show, in order to resist or compel arbitration, you don't need to show that you've suffered prejudice as a result of the party's delay in seeking arbitration. So here's basically what it means. I think parties seeking to enforce arbitration agreements should move to compel arbitration promptly. They should avoid engaging in unnecessary or discovery or any actions that might be indicative of their intent to litigate in court rather than arbitration. And the other takeaway is that now this court, California, is now consistent with the federal law in terms of compelling arbitration cases. All right, Monty,
all right, Hayward, advance the slide. So what the case Mike was talking about also shows that California law is always evolving. Sometimes our courts are making new laws or modifying the laws that have been on the case books in a while. Sometimes our laws get modified because the U.S. Supreme Court issues a new ruling. That's what happened in that case that Mike was talking about. So in this case, Castellanos versus State of California, everybody probably remembers when the new services like Uber and Lyft were developed, and then the California Supreme Court came down with the Dynamex decision. There were all these issues about, well, can these people who are drivers be independent contractors, or are they now employers? And then one of the ways that the people like Lyft and Uber tried to deal with that. So they got that Proposition 22 on the ballot, and that was approved by California residents. That basically said that people in those capacities are going to be independent contractors. Well, in this case, there was a challenge, and the challenge was that this Business and Professions Code Section 7451, which was created by Prop 22, was that unconstitutional. And the Court of Appeal had reversed the trial court, which it's concluded that Prop 22 was unconstitutional. And the California Supreme Court affirmed them. And what the Supreme Court said was that Section 7451 of the BNP Code does not conflict with Article 14, Section 4 of the California Constitution, because that provision of the Constitution did not give the legislature the sole authority to the exclusion of the initiative power that we have in California to govern workers' compensation. So interesting affirmation by the California Supreme Court of that Prop 22 change. So let's go next to Mike, and we'll go to the Civil Code.
All right. Niedermeyer was the owner of a defective Jeep Wrangler and gave the dealer more than a dozen chances to fix it before asking the manufacturer to buy it back under California's lemon law, the Song-Beverly Act. The manufacturer refused, and that left the client or the plaintiff virtually no other option but to trade in the vehicle for a credit on a new safe vehicle or sue the manufacturer. The client prevailed at trial and obtained damages, but the manufacturer claimed that it was entitled to an offset against the judgment under Civil Code 1793.2. The manufacturer argued that it was entitled to a damages offset for the Jeep's trade-in value, or if the consumer sold the vehicle, they were entitled to an offset. The court said no, that 1793.2 does not grant the manufacturer a trade-in or a resale offset when the manufacturer's willful refusal to promptly buy back a defective vehicle is what forced the consumer to either trade in or sell the vehicle in the first place. And any double recovery that the consumer might receive as a result is irrelevant. So the statute was enforced fully without any offset.
Now, that issue has been an issue for a number of years in these lemon law cases, and different courts of appeal have said, well, maybe the manufacturer gets a deduction for the trade-in, but now the Supreme Court has decided it. And in Niedermeyer, that was a $19,000 difference because they would have gotten a credit of $19,000. Let's go to the next one, Hayward. Thanks. This is another Song-Beverly Act case and lemon law case. And basically, in this case, there's an issue, and this has been an issue for a number of years in these kinds of cases, and that is under Civil Code Sections 1793.2D2, when a car is considered a new motor vehicle, then there is a refund or replace provision that applies to that in lemon law cases. And what this case was the plaintiffs bought a 2-year-old car with over 55,000 miles on it, but it had an unexpired manufacturer's new car warranty. Now, the Court of Appeal and the trial court both agreed the defendants were entitled to get a motion for summary judgment granted, and the Supreme Court affirmed that in this case. And it made it clear in these kinds of cases, because other courts of appeal had been addressing the similar issue. So the California Supreme Court said that the refund or replace remedy did not apply to this car because plaintiff's car was not a new motor vehicle. Motor vehicle purchased with an unexpired manufacturer's new car warranty does not qualify under the code section as a motor vehicle sold with a manufacturer's new car warranty, because that would only apply if the new car warranty was issued with the sale of the car. And of course, that didn't happen in this case because the car was 2 years old and had already been driven 55,000 miles. So let's go to the next slide, and Mike will take us there.
Okay, next case is California Capital Insurance versus Hone. And this is the subject of this case is the time period for setting aside a default judgment. Plaintiff insurance company filed a lawsuit against the defendant for allegedly causing a fire that destroyed a building in which he resided. On several occasions, the plaintiff attempted to serve defendant with the summons and complaint, but was unsuccessful. However, on one attempt, the summons and complaint were served upon the defendant's alleged girlfriend, and a copy of the summons and complaint was then sent to his home address. Approximately a year later, plaintiff requested and obtained a default judgment against the defendant. But it was not until the defendant's wages were garnished almost 9 years later that the default judgment was that did the defendant become aware of the default judgment that had been entered against him. The defendant filed a motion to vacate the judgment on the grounds of improper service of process. And in a supporting declaration, the defendant claimed that he did not recall receiving or seeing the summons, and that his girlfriend did not live with him at the time, and that he never received any paperwork from her. The trial court denied the motion, and the Court of Appeal affirmed the decision, holding that the motion was subject to a 2-year time limit after the entry of the default judgment under California Code of Civil Procedure. You may be hearing a dog in the background. He's not a paid attendee, but he's a nuisance. All right. So anyway, that I guess this seminar is not paid seminar anyways, is it?
Nope.
Any event, okay, so I'm an amateur. So there you go. Any event, the defendant filed a motion to have the set aside. The court initially determined that the default judgment was past the 2-year time limit. The Supreme Court reversed, holding that the 2-year time limit under CCP 473.5 does not apply to motions to vacate judgments due to the improper service of process under CCP 473D. The court emphasized the importance of actual notice to prevent fundamental injustices in violation of due process rights. So when you have a void judgment now, the Supreme Court has clarified there is no 2-year statute, and you have to show a violation of due process rights in support of the void service or judgment. Okay, Monty, it's all yours.
Okay, next slide, please. So this case is City of Los Angeles versus PricewaterhouseCoopers. Very interesting case that came down last year, because this case deals with the issue of what does the trial court have as far as its power to issue sanctions for abuse of discovery. In this particular case, the trial court, I think, got pretty fed up with the actions of a party, and they ended up issuing against the defendant a sanctions award of $2.5 million. And so that worked its way up to the Court of Appeal and the Supreme Court. And at the trial court issued that sanction. And then the Court of Appeal basically said, well, the trial court doesn't have the authority under our Code of Civil Procedure to issue that kind of a sanction. And Basically, the Supreme Court disagreed with the Court of Appeal. And the Supreme Court concluded under the general sanctions in the Civil Discovery Act and the Code of Civil Procedures, sections 2023.010 and 2023.030, the trial court did have the authority to impose monetary sanctions for plaintiffs' for the pattern of discovery abuse. The trial court was not limited to imposing sanctions for each individual violation of the rules governing depositions or other methods of discovery. So one of the things that we've seen over the years is people will get involved in these discovery arguments, disputes, often going back and back and back. And this case really does indicate that the trial court has some very significant authority to issue some very significant sanctions. And so people need to be aware of that who are involved in civil litigation practice. So Mike, you're going to take the next one.
Okay, that would be Meinhardt versus City of Sunnyvale. This was a mandamus action to set aside, it was a CEQA litigation. Mandamus actions are the method used to challenge approvals of environmental quality proposals under CEQA. And the trial in these kind of cases is basically based on exclusively on the administrative record. So when the filing, here the question, let me just kind of go through some of the facts here. I'm not sure this is broadly interesting to necessarily everybody here, but this case clarified when you appeal a decision on a mandamus case. In a mandamus actions, it's not always clear when the judgment is entered, because there's a lot of interim orders and findings that make it somewhat confusing. Here, the Superior Court filed and then served an order containing its factual and legal rulings, stating that the petition for writ of administrative mandamus was denied. The following month, the parties signed and submitted to the court a document entitled Judgment, summarizing the order and containing a signature line for the judge to enter judgment. The court signed the judgment, and it too was served on all the parties. The plaintiff appealed within the statutory time limit if measured from the service of the judgment, but it was untimely if it's measured from the entry of the previous order. It might seem obvious that the document entitled Judgment would be the judgment for purposes of appealability. However, the City of Sunnyvale argued that the prior order met all of the criteria to be considered a judgment as well. And the date for appeal started then, and it was therefore untimely. The California Supreme Court found that the applicable statutory framework requires or states that orders granting or denying a writ are non-appealable. Only the subsequent judgment is appealable, and therefore it held that the subsequent judgment is the paper that triggers the time to appeal. So it seems fairly obvious to me, but nevertheless, the City of Sunnyvale made a very interesting argument, and they were able to sell that to some court.
Next slide, please. Okay, so in this case of North American Title Insurance Company versus Superior Court, this was a case dealing with disqualification of a judge, and in the Code of Civil Procedure sections dealing with this, there is a section 170.3b2 that precludes a waiver of a party's right to seek judicial qualification. But the issue that was dealt with in this case was, there's a judicial disqualification where somebody is filing a disqualification statement against the judge. So one of the parties is claiming they're disqualified. Or you can have a judicial disqualification because the judge brings up the issue thinking they may be disqualified. And so in this case, we had a difference of opinion between the Supreme Court and the Court of Appeal. And the Court of Appeal had ruled in the case that the non-waiver provision set forth in CCP 170.3b2 precluded waiver of a party's right to seek judicial disqualification when the claim would otherwise have been barred by the requirement in section 170.3c1 requiring that the disqualification should be made at the earliest practicable opportunity. Now, the California Supreme Court disagreed, and the California Supreme Court said, no, the non-waiver provision in 170.3b2 applies only in circumstances of judicial self-disqualification, where the judge has determined himself or herself to be disqualified and absent an explicit waiver of disqualification by the parties would recuse themselves from the proceedings. The non-waiver provision, says the Supreme Court, is not applicable when a party seeks disqualification by filing a written verified statement of disqualification. And so that's a clarification in that case. Now, the facts in this case are kind of interesting, and I think it also helps us understand why the Supreme Court came to that conclusion. There was a wage and hour case in the underlying case. There was a bench trial, and then by 2016, the trial court found the defendant was liable. Then over the course of several years, the defendant engaged in restructuring. Then there was a hearing in 2020 where the parties were considering issues, and the judge mentioned it kind of looked like the defendant was engaging in a shell game, which was being argued by the other party, trying to avoid being able to collect on the judgment. Now, in 2021, a new defendant was named, and they filed a statement of disqualification. Now, they quickly filed it, so there's no timing issue, but this new defendant was later dismissed. Now we go to 2022, and the original defendant who had this statement of disqualification, who had the judgment against them, who the judge had made the hearing of remarks about 2 years earlier, it files a statement of disqualification based upon the comments from those hearing 2 years ago. And then later in 2022, the judge enters judgment against that defendant for $43.5 million. So basically, this statement of disqualification was way too late, and the Court of Appeal was wrong in saying, no, they couldn't waive that argument. So let's go next to the next slide, and Mike will take us on that one.
Tri-Coast Builders. Here, the defendant in this litigation demanded a jury trial and posted jury fees. The plaintiff did not request a jury trial and did not post jury fees. On the morning of the trial, the defendant informed the trial court that he was waiving a jury, and the plaintiff immediately objected, stating it would be posting jury fees that same day, was prepared and wanted a jury trial, and was not waiving. The trial court denied plaintiff's request because plaintiff had already waived by failing to post the jury fees. That the trial court acknowledged that a plaintiff could challenge the court's ruling by filing an extraordinary writ if it chose to, but the plaintiff didn't do that. After a bench trial and following an adverse judgment against the plaintiff moved for a new trial, arguing that the trial court had abused its discretion by denying its request for relief from the waiver of its jury right. The trial court denied the motion, again, pointing to the failure of the plaintiff to pay jury fees. The California Supreme Court, I'm just going to jump to it, ruled that Section 631G does not limit a trial court's discretion to grant or deny relief from waiver in the absence of showing of hardship to the trial court or the opposing party. And it also found that the trial court was not required to grant plaintiff's request for relief from waiver after it established that no hardship would result from a jury trial. It also established that if, in fact, you have been determined, or it has been determined that you've waived your right to a jury trial, the way to challenge that from the trial court is by a writ. And the Supreme Court was very critical of plaintiffs' lawyers for not pursuing that avenue and upheld the jury trial waiver. Okay, Monty?
Next slide, please. So now we're going to move into the area of employment law. And this case, Bailey versus San Francisco District Attorney's Office, this is a significant new case by the Supreme Court last year. And this deals with an employment issue and FEHA claims by a plaintiff. Now, the trial court granted the defendant's motion for summary judgment in this action, and the Court of Appeal affirmed. And there are cases in the employment area, and they talk about incidents that may happen to an employee who's a plaintiff. And if it's a one-time event or something that's not happened very often, it may not be actionable. But in this particular case, there was a one-time event in terms of a word that was stated, and it was the N word, as the court discusses it. And basically, the plaintiff was somebody who worked in this district attorney's office, and a coworker called her the N word. Now, after this happened, she reported the incident, and the claim that she made in her lawsuit was not only was that word spoken to her, but her HR manager later obstructed her from filing a formal complaint, engaged in threatening conduct, and threatened her by saying, "You're going to get it." So the Supreme Court reversed the trial court and the Court of Appeal, which had said, nope, summary judgment should be granted. The Supreme Court concluded the following: a coworker's one-time use of a racial slur may be actionable in a claim of harassment. Such an incident may be so severe as to alter the conditions of employment and create a hostile work environment. An isolated act of harassment may be actionable if it is sufficiently severe in light of the totality of the circumstances, and a coworker's use of an unambiguous racial statement such as the N-word may be found to suffice. The Supreme Court also concluded that a course of conduct that effectively seeks to withdraw an employee's means of reporting, this is the HR person's conduct, and addressing racial harassment in the workplace may be actionable as a claim of retaliation. Such conduct may constitute an adverse employment action. And applying these standards, the California Supreme Court basically said there was a tribal issue of fact, and the summary judgment should have been denied. So this case is telling us there may be a FEHA claim and an employment claim for a one-time statement of a terrible claim or word, the N-word, but that may be sufficient. That's what the Supreme Court found in this case. So let's go to the next employment case, and Mike will discuss that.
Estrada, another PAGA case. Basically holding that trial courts do not have the inherent authority to strike unmanageable PAGA claims. Here, the plaintiff sued the defendant for various wage and hour violations, including failure to provide first and second meal breaks and all for derivative civil penalties under PAGA. The claims involve 13 plaintiffs. They sued on behalf of themselves and others as a class and as well as representatives of aggrieved employees under PAGA. At the end of the trial court, there was I think there was a couple of subclasses that had been certified. At the end of the trial court decertified the classes, citing a predominance of individualized issues that rendered class treatment unmanageable. The trial court also dismissed or struck the PAGA claims on the grounds that they were too complex and unwieldy to proceed. That is, they were unmanageable. The court found here that the manageability is not a valid basis for dismissing PAGA claims. The court went on to explain in its holding that the court has various tools available to it to ensure that PAGA claims are effectively tried. For example, you can limit testimony, you can determine the types of evidence, you can use representative testimony, you can use surveys, statistical analysis, etc. However, the court's ruling again acknowledged that even the full toolkit may not be sufficient to protect an employer's due process in certain circumstances. So, although the court held that here you can't strike or eliminate PAGA claims because they're unmanageable, the court offered no clear guidelines on when the trial courts should utilize their toolkit, nor did it define what constitutes an unfixable claim that defies fair processing. So this vagueness presents a challenge in discerning the appropriate approach for exceptionally intricate PAGA cases and identifying claims that are too problematic for standard legal structures. Furthermore, this case leaves unanswered questions about the approach that the court should take in particularly complex PAGA claims, and the threshold at which a claim becomes too burdensome for fair adjudication. So I think from the start, the issue is going to be from the defense side. You're going to start looking, when it comes to PAGA claims, at whether or not the presence of too many individual and separate evidentiary claims are not suitable for a class type determination. At what point does it violate the defendant's right to due process? I can see a lot of litigation coming up because of this case.
Well, this case also shows another interesting issue, and that is, while PAGA has been on the books for, I think, over 20 years, a lot of trial courts still don't understand PAGA is not a class action. And so this trial court was trying to use class action procedures in managing it. And the Supreme Court made it clear it's not a class action, and you don't have those. Now, another factor that's going to bear on this is you probably know that effective on June 19, 2024, for any PAGA actions filed after that, there has been an amendment to PAGA. And basically, based upon those amended PAGA rules that give defendants rights to try to limit potential damages and exposure, that those reforms allow trial courts to consolidate or coordinate civil PAGA actions with overlapping claims against the same employer. And those are pretty common. A lot of people file different actions against the same employer with overlapping claims. So those reforms are going to come into effect. But just remember, PAGAs are not class actions. So let's go to the next slide here.
Monty, just one comment on that. We're going to be talking in a little bit about the Turrieta case versus Lyft, which deals with that same issue of how do you manage multiple PAGA lawsuits.
Yep.
All seeking to represent the same aggrieved employees on the same claims.
Right. So let's go to the next one, which is Huerta versus CSI Electrical Contractors. Now, in this case, the California Supreme Court answered 3 questions from the United States Court of Appeals for the Ninth Circuit. And this is fairly common for the California Supreme Court if you track these cases. Sometimes the Ninth Circuit, and it'll usually have some kind of a case where there's diversity, but they have to apply California law. That's the issue, how it comes up. There may be an issue where the courts of appeal are divided and have different results, and the Supreme Court has not issued any ruling, or there may be an issue before the Ninth Circuit trying to apply California law where there is no law. And so the California Supreme Court is pretty regularly asked by the Ninth Circuit questions, and that's what happened in this case. And this was a wage and hour case. And basically, the question was, this Ninth Circuit wanted to know what the California Supreme Court would determine about how the wage order should be applied in this case. So the question was, an employee's time, one of the findings was, if an employee spent time on an employer's premises awaiting and undergoing an employer-mandated exit procedure that includes the employer's visual inspection of the employee's personal vehicle, is that compensable as hours worked within the meaning of Wage Order 16? And the Supreme Court said, yes, it is. Number 2, the time that an employee spends traveling between a security gate and the employee parking lots, is that compensable as employer-mandated travel under Wage Order 16, Section 5A, if the security gate was the first location where the employee's presence was required for an employment-related reason other than the practical necessity of accessing the worksite? And the Supreme Court said, yes, that is compensable time. And then third, what happens when an employee is covered by a collective bargaining agreement that complies with Labor Code Section 512E and Wage Order 16, Section 10E, and provides the employee with an unpaid meal period? Is that time compensable under the wage order as hours worked if the employer prevents the employee from leaving the employer's premises or designated area during the meal period, and if this prohibition prevents the employee from engaging in otherwise feasible personal activities? And the answer to that is yes. So the Supreme Court answered those 3 questions for the Ninth Circuit. So next, we'll go to another employment case, and Mike will talk about this with the wage statement issue.
Yeah, this is in Nerano, the employer indicated that they reasonably in good faith believed that the wage statements they had issued were compliant with the requirements of law. And the California Supreme Court says an employer's objectively reasonable good faith belief that it has provided employees with adequate wage statement precludes an award of penalties under Section 226.
All right, so let's go to the next one. And this is another wage and hour case, Stone versus Alameda Health System. This was a PAGA claim as well. And basically, the Court of Appeal had concluded that a public health authority could be liable for wage and hour violations under PAGA, and the Supreme Court reversed, disagreeing with them. The trial court had sustained a demur of the defendants without leave to amend, concluding that the labor code applies only to private sector employees unless they are specifically made applicable to public employees. The Court of Appeal disagreed, but the Supreme Court said, nope, the PAGA and wage and hour claims do not apply in this circumstance. Basically, the Supreme Court said the legislature intended to exempt public employers such as the hospital authority from labor code provisions governing meal and rest breaks and related statutes governing the full and timely payment of wages. And it also concluded that public entities are not subject to PAGA penalties for the violations that had been alleged in this action. So while PAGA is very far-reaching, the Supreme Court decided very clearly in this case it did not and does not apply to public entities. Let's go to the next employment case, and Mike will discuss that.
Okay. In this case, plaintiff Turrieta brought a PAGA action against Lyft, claiming that she and other drivers were being misclassified as independent contractors. Turrieta and Lyft mediated the case and ultimately agreed to settle the dispute for $15 million, with Lyft agreeing to pay more than $3 million to the state's Labor and Workforce Development Agency, as PAGA requires. As PAGA requires, the parties gave the LWDA notice of their settlement. Olson, who is another plaintiff in a separate action alleging PAGA claims against Lyft, when Olson learned of the settlement, here Olson was another party. Turrieta moved for approval of the settlement, and Olson moved to intervene in Turrieta's action. The trial court denied Olson's motion to intervene and approve the settlement, ruling that Olson lacked standing to intervene since the state was the real party in interest. The court held here that a PAGA plaintiff does not have a right to intervene in an ongoing PAGA action of another plaintiff asserting overlapping claims, or doesn't have the right to object to a proposed settlement or to move to vacate a judgment in that action. So one could say that this case means that this court's opinion will create a race to settlement or judgment in PAGA actions that involve overlapping claims. The first representative action to reach a settlement or a judgment will resolve the overlapping claims, and the PAGA plaintiffs in other actions will have no automatic right to intervene or to move to vacate the first in-time judgment. The court expressly reserved the question of whether the state itself, separate from a representative plaintiff, could object to a proposed settlement. So in future cases, as Monty previously discussed, I think we're going to be looking at other ways of managing separate PAGA claims other than intervention, including the right of plaintiffs to seek consolidation or coordination or outreach by other PAGA plaintiffs to the LWDA at the settlement approval stage.
Okay, let's go to the next slide. And thank you, Hayward. So now we're going to the area of insurance. This case, Another Planet Entertainment, LLC, the California Supreme Court finally decided an issue that started to raise its head during the COVID-19 pandemic. I can remember in 2020 when businesses were shut down and everybody was restricted. There was a lot of press coverage about lawsuits being filed by businesses trying to make claims against their insurance companies to get money for the loss of the business by being shut down by authorities. And I've done a lot of bad faith cases on both sides, actually more plaintiff, but I've also defended bad faith cases in my career. And while I'm not a coverage lawyer, like some of the coverage exclusive only lawyers, it was clear to me that in these property casualty cases, it would probably be difficult to get coverage with a virus because usually you have to have property damage, and that kind of became the issue. And so all these cases were filed, and you started seeing decisions get up in the Court of Appeal by 2021, 2022, and 2023. And it was really pretty consistent rulings at first, but then you saw some variety. Courts of appeal were taking different positions. And most courts said, nope, there isn't any kind of a property damage by a virus. Other courts said, no, if the plaintiffs have alleged that the virus has attached to the wood or the particles of some of the property on the premises, that maybe there is property damage and the case can go forward. Well, that's what happened in this case. The Supreme Court, once again answering a question from the Ninth Circuit Court of Appeal, answered this question finally, and the issue was whether the question posed by the Ninth Circuit was, can the actual or potential presence of COVID-19 virus on a premises of an insured constitute a direct physical loss or damage to property for purposes of coverage under a commercial property insurance policy? Supreme Court said no. The actual or potential presence of the COVID-19 virus on the premises generally does not constitute direct physical loss or damage to property within the meaning of commercial property insurance language under California law. So any of the plaintiffs who had survived emerged with their creative arguments of, well, it's attached and it's kind of commingled with the particles of the wood or the other parts of the property, they were out of luck. And the Supreme Court made it very clear. And so that is the issue decided by the Supreme Court. So next insurance coverage case Mike will talk about.
All right. It's another COVID case arising, a coverage case arising out of COVID. John's Grill was a restaurant in San Francisco which suffered significant financial losses during the COVID pandemic and sought compensation from its property insurer. The carrier denied the claim, stating that the losses did not fall under the policy's limited fungi, bacteria, or virus coverage endorsement, which only covered virus-related losses if the virus results from specific causes like windstorms or water damage. John's Grill argued that this limitation made the virus-related coverage illusory and unenforceable. The Superior Court sustained the carrier's demur, finding that the policy language clear and enforceable, and the court reasoned that the specified causes of loss could potentially cause virus damage, thus the coverage was not illusory. The Court of Appeal reversed, agreeing with John's Grill that the specified cause of loss limitation rendered the virus coverage illusory, as the listed causes were not realistically related to virus transmission. And the Supreme Court of California reversed the Court of Appeal. And the court held that the policy's specified cause of loss limitation was clear and unambiguous and thus enforceable. And it concluded that John's Grill did not have a reasonable expectation of coverage for pandemic-related losses under the policy. The court also determined, or at least mentioned during the course of its decision, that California has never really had a doctrine called illusory coverage, and as articulated in John's Grill, and it didn't approve of that as a basis on which to find coverage against a carrier. Although many cases under the coverage realm talk about based on a reasonable expectation of the insured, that the limitation on coverage or the exclusions from coverage would make the particular coverage illusory.
Okay, next case is another insurance case. Now, in this case, you had an interesting decision by the Supreme Court. If somebody has a claim denied by their carrier and they later file an action for breach of contract and bad faith, which are the common claims, basically, Insurance Code Section 2071 provides a one-year statute of limitations. And if you don't file it timely, you're out of luck. Well, in this case, this plaintiff actually filed 2 lawsuits dealing with their denial of their claim. One lawsuit did allege breach of contract and bad faith. That was removed to the federal court and dismissed because of failure to meet the 1-year time limit. The other lawsuit, which is the one that got to our California Supreme Court, is this one. And this was a lawsuit where she said, well, I'm actually suing for under the unfair competition law and also the False Advertising Act because I want to get kind of a change of their claims handling policies and procedures. And so basically, what the Supreme Court said was, well, it was wrong for the trial court to sustain the defendant's murder without leave to amend, and for the Court of Appeal to affirm that, finding this case was untimely under the 1-year statute of limitations under Insurance Code Section 2071, because the Supreme Court said this claim was not for breach of contract and was not for bad faith, which that section applies to, but instead it was an attempt to directly, it was basically an attempt to get declaratory relief regarding the claims handling practices generally and a forward-looking injunction under the unfair competition law. And therefore, the statute of limitations that applied was the 4-year statute of limitations under the unfair competition law, and the dismissal of the action was reversed. So let's go to the next case, Mike. It's another insurance case.
Right. This is Truck Insurance Exchange versus Kaiser Cement. It is a case that involves continuous injury claims, and it's a dispute among carriers, first-level excess carriers, for coverage of continuous injury that fell within their policy periods. The issue presented was whether or not the Montrose Doctrine applied to excess carriers, and whether or not there had to be a horizontal exhaustion of underlying coverage before the excess carriers were on the hook. But in this particular case, the Supreme Court applied the same, first found that the underlying, it was only vertical exhaustion that was required. In other words, the primary coverage under the first level excess coverage had to be exhausted under that particular policy, not totally, and that the time on the risk type of equitable contribution would be applicable here among the carriers who had that first level coverage. They found that the language of the first level excess policies at issue in this case was essentially identical to the policy language in the higher level excess policies that the court had considered in Montrose 3. So they found vertical exhaustion is all that is required, and they're left over a number of questions as to how the equities or were to be applied and which carrier was responsible for how much.
Okay, we're at the end of our time here, and basically, for the people who got the written materials, you will notice there are some additional cases we won't discuss dealing with probate, real property, torts, and also settlement. And those are all also significant cases. So take a look at those. And you will find, I think, that these 1-paragraph summaries are very helpful. And people who have subscribed to my California case summaries have found that they help them always know the new case law in their practice area, helps them get better results in their cases. So we're happy to have discussed these things with you. Remember, you can get a free 3-month summary if you mediate with me this year for a half day or a full day. And Hayward, thanks for letting us talk today. We appreciate the opportunity.
Thank you, Monty, and thank you, Mike. I apologize to everybody. There's just a lot of information on for this presentation itself, but as Monty mentioned, you will have the written materials available to you. We have been informed that some of the links are not working on the written materials, so what we'll do is update it by the end of today. And so please check back on our ADR Services CLE webpage, and then you should you should be able to access the updated written materials there. Again, thank you, everybody. Just as a reminder, your CLE certificates will be emailed to you at by the end of this week. This presentation has been recorded and will be available on our YouTube channel shortly. And that's it for today. Thank you again to our speakers. Thank you, everybody, for joining us. I hope to see you on the next one.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.